Welcome to today's webinar. I'm Scott Lunow and I'm accompanied by Ben Volker. And today we're going to be talking about estate planning for 2026 and beyond. Estate planning is always a good topic to discuss, but it's really pertinent now because of the 2026 estate tax law sunset that's going to occur on December 31st, 2025. And what's going to happen then is that the estate tax laws are going to revert to what they were in 2017. Now, before we get into the details, let's talk about a housekeeping matter, Ben. Next slide. So you definitely will be able to submit questions. Just go to the bottom at your Q&A option there at the bottom of your screen and type in your questions. If we are able to, we'll get to them during the conversation. Otherwise, we will talk to them about them at the end. All right, next slide. So before we start talking about any specific techniques to deal with estate taxes and estate planning, it's important to spend just a minute talking about the basics. And there's two distinctions here. There's standard estate planning and there's advanced estate planning. And everyone, we would argue, should have a standard or basic estate plan in place. And it doesn't matter if you have a $100,000 estate or a $100 million estate, all of the people in between there are going to have the same basic estate plan to a large degree. And that includes your ancillary documents like your medical and financial power of attorney, typically a will and a revocable trust that handles, that is the primary operative document. Now, if you have all of those documents in place, that's great. That'll then open the door to looking at your situation and seeing if you have any estate tax exposure, looking at your family situation, your assets and what your goals are, and then seeing whether any advanced planning techniques are appropriate for you and your family. Now, we're going to get a little bit more specific on the next slide, and we're going to talk about what a standard estate plan typically looks like. This is what Ben and I would describe as the standard estate plan for a married couple. And 90% of the time, the diagram or the estate plan is going to look something like this. And as I mentioned, you see those three dark boxes, the medical, financial power of attorney, and the living will. Those are those ancillary documents that apply if you're incapacitated. And, it'll allow someone else to make medical and financial decisions for you during that time of your incapacity. Now, from the estate plan standpoint, this is a diagram that shows a husband and wife who each have their own separate revocable trusts. Now, in community property estates, a lot of the times we see a joint revocable trust shared by both spouses. Both work just fine. And then the revocable trusts contain all of the terms and provisions of what happens if a person becomes disabled or when they die as it pertains to their assets. Now, in this standard husband and wife estate plan, there are usually two trusts that are created when the first spouse dies. And that is a marital trust and a bypass trust, which is otherwise known as a credit shelter trust. And the credit shelter trust, which can be created expressly, or in this case, via a disclaimer, which is a flexibility option. The credit shelter or bypass trust is there to receive the remaining estate tax exemption of the first spouse to die. And as we're going to talk about in a minute, that estate tax exemption is a moving target. And the marital trust typically holds the balance of the assets. One of the things we talk about a lot of times when we talk about trusts for children is protection from creditors and predators. And this marital and bypass trust actually provides protection from creditors and predators for the surviving spouse. So there's a definite benefit to having that type of plan. Then if you go down to the next level, then we see that in your standard plan, there are typically trusts created for children. Here there are 4 kids in our example. Each trust would get 25% of the residue. And as the parent, when you're creating your estate plan, you have complete control over what those trusts say, what they do, what level of creditor protection they provide, whether there's divorce protection, protection from lawsuits, and then also the taxability of those trusts. And then last but not least, one of the reasons why a lot of estate plans fail is because people don't coordinate the titling of their assets with their estate plan. And that pertains to the jointly owned property or assets with a beneficiary designation. Those assets pass outside your estate plan. I actually just looked at a balance sheet for some clients this morning where 90% of their assets passed by rights of survivorship. And they were shocked to know that the bypass and the marital trust that they have created in their documents are basically not going to be funded because all of the assets pass outside the estate plan. The same is true for assets with beneficiary designations like life insurance and retirement plans. Now, before we get into any specific techniques, let's take a flashback into history to see what the estate tax law looks like and where it's been.
Thanks, Scott. So this is a visual representation of the estate exemption going back to the year 2001. I'm a bit of a history buff myself, and so I've researched kind of the origins of the estate tax, well before 2001, and it was the late 1700s when our newly founded nation was struggling with trade relations with France, and they instituted the very first estate tax in order to strengthen our U.S. Navy, and that came into being in 1797. The amount of that tax was 50 cents on any probated will. So things have clearly changed over time. That lasted until a little after 1800 in 1802, and then estate taxes went away. And it wasn't until the 1860s when they came back in 1862 to help finance the Civil War. And so those taxes last until about 1870. And after that point in time, they went away again. And in 1917, a similar version to what we have today was introduced, although these exemptions have been, as Scott said, a moving target over time. I would encourage you to look here where my cursor is, 2023, that's where we sit today. And each individual can pass $12.92 million to their heirs free of gift and estate tax. So a married couple would have just shy of $26 million of tax-free transfer. The federal tax rate on anything above that is 40%. How did we get to where we are today? In 2017, the Tax Cuts and Jobs Act substantially increased the exemption from where they were, around $5.5 million, up to over 11 million. But as Scott mentioned, that Tax Cuts and Jobs Act will sunset at the end of 2025. And the impact that that could have on these exemptions is substantial. Now, we don't know exactly what the 2026 number would be because there is an inflationary adjustment that will occur in 2024 and 2025. But back of the napkin math, we anticipate those exemptions will drop to between $6.5 and $7 million per person. So a married couple may lose up to $12 million of combined exemption. The other date I want to bring your attention to in this slide is the year 2010. In the year 2010, there was another provision introduced into the tax code federally that had a major impact on how we look at estate taxes, and that's something called portability. Prior to 2010, the funding of that bypass trust that Scott just showed on the previous slide was necessary in order to capture the first spouse to pass's exemption amount. So that separate trust structure had to be created. If it wasn't, we lost the first spouse's exemption. In 2010, portability allowed for a surviving spouse to file a tax return, IRS Form 706, and essentially inherit their deceased partner's exemption without creating a separate trust. That provision was made permanent in 2012 and stays in place today. But when I look at this slide over the last 20 plus years, and we go back to 2001, the exemption was $675,000. It is 19 times larger today than it was in 2001. So one of the things that we want to look at, we want to talk about today, are ways that we can strategically utilize this higher exemption amount to minimize the ultimate estate tax that can be due when we pass away. And we plan to do that in two ways. We're going to have a qualitative discussion about some of these strategies and explain the mechanics of how they work and the pros and potential cons. And then we want to quantitatively show the impact that that can have using our financial planning software, which is called Mariner GPS. So I'm going to click over.
So our hypothetical clients are John and Mary Smith.
They are. So now we have John and Mary up in front of us, and they are truly hypothetical clients, but we've assumed that John, age 65, Mary, age 63. We've assumed that John will pass first, Mary will pass second, and Mary will pass in the year 2055, so 32 years from today. As we look at their estate today and the potential tax liability, we have John passing first, transferring all his wealth to Mary. That can be done using something called the unlimited marital deduction, which means there's no tax due in transfers between spouses. When Mary passes, you'll see a small amount of tax and expenses shown, but that is what we call income with respect to the decedent. And that would be income tax due on distribution from John and Mary's retirement assets to their heirs. Their estate tax today is zero. However, if we fast forward to 2026, where we shared is the big change in the exemption, John and Mary's net worth has gone up slightly as their assets have grown over time. There is still no tax due when John passes, but when Mary passes, this line item has changed substantially. And now we have $1.6 million of estate tax liability that is due upon Mary's death. So that change to the estate tax exemption in 2026 and just a small increase in their total net worth has resulted in over $1.5 million of more tax. If we pull this out all the way to the end of Mary's life, our projections change again. Now, Mary's estate has gotten substantially larger. When John passed, his estate transferred to Mary still tax-free, but now the expenses and tax that are due at the time of her passing are over $5.5 million, right? So looking out to life expectancy for John and Mary, their tax liability has now increased substantially. So Scott, why don't you walk us through one of the strategies that John and Mary could consider looking at in order to try and manage this estate tax liability?
Will do, Ben. So before I get into the details of a life insurance trust, I just want to emphasize one point that Ben just made. And if you haven't done so already, if you have a taxable estate right now, you're going to have more estate tax exposure in just a couple of years when the estate tax law sunsets. But what a lot of people don't realize is those people that don't have a taxable estate now, we're finding a lot of clients haven't really thought about it. So if you don't have a taxable estate now, but you could have one in 2026, the question is, what could you do now to possibly get ahead of that? And one of the techniques that was very, very often and heavily used when I first started practicing law was the life insurance trust. We call it an ILIT, which stands for Irrevocable Life Insurance Trust. And we predict that it's going to make a comeback. And the ILIT is really useful for two purposes. One is it allows you to get what is typically a very large asset out of your estate for estate tax purposes. So if you have a life insurance policy with a death benefit of $1 million, $3 million, $6 million, here in our case, our hypothetical clients have a $4.25 million life insurance policy, you can create this special irrevocable trust and place a life insurance policy in it, or the trust can purchase it if one doesn't exist yet. And that very large asset with that death benefit can be out of your estate for estate tax purposes. So on the left, you see again that standard married couple estate plan with the pour-over wills, the revocable trust, the marital trust, credit shelter trust. And that line there to the right is that line of demarcation showing that that ILIT is not in their estate for estate tax purposes. So that $4.25 million policy that if that were in the estate, it would trigger a 40% estate tax, which would be, over $800,000 of estate tax that you're saving by creating this life insurance trust. So the first reason or benefit of a life insurance trust is to get that large asset out of your estate. But what's the second reason? Many clients that we work with have liquidity problems in their estate. And what I mean by that is they have lots of assets, such as maybe real estate, private equity, business interests. They're very valuable assets, but they're not liquid. And the last thing that you want to do when a person dies is to have their executor or trustee have a fire sale to sell real estate or sell a business interest and get pennies on the dollar. So the second reason or the second benefit of a life insurance trust is that in this case, this $4.25 million could be available to help pay the estate taxes if it were a taxable estate. So again, getting that large asset out of your estate is the first reason. And the second one is providing liquidity for the payment of estate taxes. And as I mentioned, I think we're going to see more and more of these life insurance trusts as people start to realize their estate tax exposure and if they have a liquidity problem. So Ben, sometimes when we talk to clients, they like to sort of explore the boundaries. And sometimes clients ask, well, what could I do to totally eliminate estate taxes? Is there a way to do that? And you already mentioned the unlimited marital deduction, which is why there's no estate tax at the first death, but there's also the unlimited charitable deduction. So is there a way that clients can structure their estate plan to eliminate estate tax using the charitable deduction?
Absolutely. So I've always said this, and sometimes you get an inquisitive look from a client or sometimes even their trust and estate attorney, is estate tax is a voluntary tax. It is not one that you have to pay, because anything that you leave at your death to charitable organizations is not subject to estate tax. And so there is a way with certainty to ensure that at the time of your passing, whenever that may be, there will be no estate tax due. And the way that's done is by setting up a formula clause inside of your estate plan that says at the time of my death, the maximum amount, whatever that exemption may be, goes to my heirs, and everything else goes to a charitable beneficiary of my choosing. And so we max out the tax-free transfer to individual beneficiaries. We allocate everything left to charitable beneficiaries. And the result is that we have no estate tax to be due at the time of passing. Now, there's a lot of considerations that we have to look at when we're thinking about putting a plan like this in place. How big is the overall size of the estate? What will that exemption be in the year of death? Did you make any taxable gifts previously, because that decreases the amount you can leave tax-free at your passing? How much goes into the child's trust and how much is divided amongst charities? So as I look this as a strategy, I think about the benefits. The first is we've got an obvious benefit that we avoid estate taxes completely. We also are going to provide for children up to the exemption at the time of your passing. This goes into the question of how much is enough for your kids and how much do you want to leave to other beneficiaries. If under current tax law, you were comfortable that if you left $12.92 million to your children, they would be sufficiently cared for their lifetime and probably subsequent generations, then the idea of leaving the rest to charity is more palatable. And then also you have a charitable benefit. So if you have philanthropic goals and objectives, they can be satisfied with this type of estate plan. The risk to this type of planning, as I see it, is we always hear the adage that there are only two things that are certain in life, death and taxes. And I don't disagree with that, but both of those things also have a ton of uncertainty around them. So I can't predict with any clarity when someone's going to pass away, nor do I know what the estate tax exemption is going to be at that time. So there is some risk that you don't know with certainty exactly how much would end up in that trust for the benefit of your children. So again, there are pros and there are potential cons to this type of strategy. But I want to take you back to our eMoney software program, and I want to illustrate what this zero tax formula could look like if it was employed as part of John and Mary's estate plan. So we've looked at this slide before, which is the estate tax liability that is due at Mary's passing. And I want you to take a look at the total amount that goes to heirs after tax, which is $35.6 million. If we were to zero out their estate so that no taxes would be due, you see that we end up with a 14 or just over $14 million gift to charities and $27.1 million that's left for the heirs. So as we think about our total transfer to beneficiaries, this aggregate number, it has gone up between $5 and $6 million. And it's gone up because we've kept the federal government out of being a beneficiary of John and Mary's estate plan. However, the total amount to heirs has decreased from 35 million to call it 27 million. This goes back to my previous comment about how much is enough for that next generation. If John and Mary had 3 children and they were comfortable that $9 million per child would be sufficient to provide for their kids and ultimately their grandkids, and they had a philanthropic intent, this is a way they could, in their minds, sufficiently provide for heirs and at the same time maximize their charitable and philanthropic benefit. And most importantly, in a plan like this, we take the tax man out of the equation. You'll see there is a little tax shown on this illustration as income with respect to the decedent. That's the distributions from the IRAs. In a well thought out plan, we would actually leave those IRAs to the charitable beneficiaries, so that line item would be zero. As we go back to other strategies that we might want to look to employ, if a client doesn't have philanthropic intent and is really focused on how do we maximize the net to heir number as part of their estate plan, what kind of vehicles should they be looking at in advance of this potential change to the estate tax exemptions?
Yeah, one thought before we go there, Ben. When we introduced this zero estate tax formula strategy, I mentioned that if you want to explore one of the extremes. So it's interesting. Estate planning is really finding out where you are on certain spectrums of your appetite for complexity, and specifically for your appetite for taxes. So what I would say is, if you say the number going to the children that I want that to be higher, then you have to be comfortable with them paying a certain amount of estate tax. And that's okay. If you say, you know what, if my executor had to write a check for $1 million or $2 million, I could live with that. I wouldn't be turning over in my grave. That's okay. But the point is that you need to look at those numbers and explore what's right for your situation and what's right for your family. So let's talk about one specific technique that we have seen a lot of in the past 3 or 4 years. So when clients come to us and they say, we have an estate tax liability and we want to see what we can do about reducing, minimizing, or even eliminating it, one of the first questions we ask is, are you willing to do any lifetime gifting? Because what's been happening the past several years is that, as Ben mentioned, we have this $12.92 million exemption. And to the extent that you can use that during life, you will have locked that in. The IRS has said that whatever gifts are made, they're not going to claw those back, right? So the question is, are you willing to do any lifetime gifting? And if the answer to that is yes, that's great. Step 1. The step 2 then is to find out who should the beneficiaries be of this lifetime gifting. And obviously you want to explore your family situation. Should that be children? And should it be outright or trust for children? Should it be grandchildren, nieces or nephews? Sometimes people have family members that have needs that can be met with trusts and gifts. There's charity. You can do a lot of charitable gifting during life that has some positive income tax implications, right? So there's a lot of different ways that you can make lifetime gifts, but it's also important to figure out how much can I give away and still be okay financially. Again, with the software that we're showing you here, that can easily be quantified as a starting point, right? How much can I give away and still be okay financially to have all my cash flow needs met, have a safety net? That can be quantified. If you still say, you know what, I'm not 100% comfortable giving away to kids or charities, is there a way for me to have somewhat more of a measure of control or maybe some access to that money? Then this next technique is really the next best choice. And that's a spousal lifetime access trust. We love our acronyms, so we call them SLATs. And all a SLAT is basically one spouse, or sometimes both spouses, creating an irrevocable trust for the other spouse, into which they place some or all of their lifetime estate tax exemption amount. So if you were to create a SLAT today for your spouse, you would have that irrevocable trust drawn up. And out of your $12.92 million exemption, you would then need to decide how much of that can I or do I want to place into the SLAT for my spouse. And there are some guidelines and rules to keep in mind. You don't want to give away so much that you impoverish yourself. And you also need to keep in mind that you have indirect access to the SLAT through your spouse. So if your spouse says, hey, I want to take a distribution from the trust to take a vacation, well, guess what? If you're married to your spouse, you're going to go on the vacation together, right? Or if your spouse says, you know what, I need to take a $50,000 distribution from the trust to remodel my kitchen, well, guess what? If you're living in the same house with your spouse, you're going to indirectly benefit from that. Having said that, the best thing to do if you create a SLAT is never to touch it. Because whatever that trust grows to during your lifetime, all of that growth will also be estate tax free. Okay, so you don't want to go creating a SLAT with the intent to live off of the trust. So I definitely wanted to make you aware of that. There are, as with any estate planning technique, a couple of downsides. And the downside is if you create a SLAT for your spouse and you then get divorced, you will lose that indirect access to that trust. And the second thing that can go wrong is that you create the SLAT and then 1 or 2 years later, your spouse unexpectedly dies. In that case, you also lose your access to that SLAT. However, you will have specified where it goes. So presumably it will go then to trusts for your children. So it will stay in the family, but you'll no longer have access to it. So Ben.
And one of the ways we plan around that premature death is the spouse that is the beneficiary. You can purchase term life insurance inside of an ILIT, so that if that spouse passes in year 1 or year 2, we create a liquidity source to provide for that surviving spouse. There's not a way that I found yet to protect against divorce. This is certainly, and sometimes an uncomfortable conversation that Scott and I have with clients that we work with. This is certainly something that you would want to proceed with while your marriage is on solid footing, because there's not a magic bullet for that like the life insurance is for premature death.
Right. So Ben, let's take a look at what a SLAT might look like in an estate plan. This is the easiest way we have found to explain what a SLAT is. Remember, I explained that if you want to create a SLAT for your spouse, you create an irrevocable trust, and then you place some or all of your estate tax exemption into that trust. Well, that sounds very similar to a credit shelter trust. And even though it's called a SLAT is really just a credit shelter trust that one spouse creates for the other spouse during life. So in this example, let's say that the husband created a SLAT for his wife and funded it with his complete $12.92 million exemption. And then the next week he got hit by the bus and he died. His estate plan says, when I die, I send the largest amount that can pass free of estate tax to the credit shelter trust, and everything over and above that will go into the marital trust. Well, in this case, there just simply won't be a a credit shelter trust, because he fully used his exemption during life, and the only thing that will be there will be a marital trust. So that's really the best way we've found pictorially to explain what a SLAT is. So Ben, can we take a look at how a SLAT works in our example here?
Absolutely. Let me turn off the zero tax formula, and we'll go back to the no plan for John and Mary Smith. And then Scott, I'll let you walk through this.
Right. So in our example, Ben, in order to make the numbers work, we didn't have John place his full exemption into the SLAT. We chose 7 million, correct?
Correct.
Right. So again, estate planning is not an all or nothing thing. Just because you can do something, it doesn't mean you need to do it all the way. You have the choice to dial in what you want that to look like. So,
and the reason we chose 7 million for this illustration is really twofold. One, we were trying to minimize or eliminate estate taxes, which we were able to do successfully. But we also wanted to make sure that the surviving spouse was going to have enough to live off of in their estate to take care of themselves in their accustomed manner of living. And as you'll see in this example, Mary's estate still has $6 million in it at the time of her passing. Her exemption covers that amount and ends up with a tax-free transfer to heirs. The IDGT, again, we do love acronyms. That is our SLAT in this illustration. That is the $7 million gifted this year and the growth on those assets during the rest of Mary's life, netting that $40+ million to heirs, which is more than $5 million, which we had shown with no planning, and substantially more than when we left an amount to charity, which would zero out the estate tax liability.
right. And then the last thing that I would point out, just to emphasize a point that you made a minute ago, Ben, about portability. I know a lot of people have portability and it's kind of confusing, but in our example, John used $7 million of his exemption to fund a SLAT for Mary, right? So if John then dies that same year, and what Mary needs to do is file an estate tax return for John. And in that return, she's going to make a portability election to port John's unused exemption to her. So, he used 7. So the remaining 5.92 million, she would port over to herself, and her exemption would be hers plus John's 5.92 unused exemption, which would put her in a really good position to have less estate taxes when she died. Of course, when the 2026 sunset occurs, her exemption is going to be cut in half.
So Scott, we've had quite a few questions come in during our presentation. And so maybe I'll start to walk through a couple of those that came in now, and we can address some of those questions that came up.
Sounds like a plan.
Okay. So a couple questions came in regarding state estate tax, and I'm going to go back to our federal tax exemption slide. This slide is specific to the federal estate tax exemption only. Many states do have a state estate tax, and those vary from state to state. Some are very low, others are higher. What I always like to point out when it comes to state by state planning is you want to work with a qualified trust attorney in your state of residency to ensure that your documents provide for the best planning for those state exemptions. So we've spent a good amount of time today talking about portability, which is the transferability of this exemption amount that started in 2010 at the federal level. While not all states, most states do not offer portability. And so in states with very low exemption amounts, we often will see this bypass trust funded with the available exemption at the state level. That way we lock in the exemption of the first spouse to pass and we don't lose it. So there were a couple of questions specific to Oregon. So I'll use Oregon as an example. In Oregon, if you do not create this bypass trust, the first spouse's exemption, which is $1 million, would be lost completely. And when the surviving spouse passes, their first $1 million of assets would be free from Oregon estate tax, but anything above that would be taxable at the Oregon estate tax rate. If we funded this bypass trust when spouse one died, with that $1 million of Oregon exemption, when the surviving spouse passes, the bypass trust, 1 million and the future growth, plus the first 1 million of the surviving spouse, transfers to heirs free of Oregon estate tax. So again, every state is different and not all states have a state estate tax. So you want to ensure that you're working with an attorney that understands the tax landscape in your state. We also had some questions come through about our software program and does it allow for the estate tax at the state level to be included in an illustration? And the answer to that is yes. So if you've got a situation that you want to model, and this is going to kind of be our closing paragraph, specific to you and your family and what your goals and objectives are, yes, your senior wealth advisor that you work with, partnered with Scott or myself or someone from our teams, can help illustrate not only that federal estate tax liability, but also the state estate tax liability.
There was also a question about filing a Form 706 to elect portability. And it used to be that you had just the 9-month period, which was standard for everyone. But I think on January 1st of this year, they changed the law so that now going forward, you have 5 years. But I do not think they made that retroactive.
Another question that came through was about the life insurance trust and the viability of putting a term life insurance policy inside of the irrevocable life insurance trust. The typical insurance structure that we see for a life insurance trust is second to die life insurance. And the reason being is because of that unlimited marital deduction. When the first spouse passes, no tax is due. And it's not till that surviving spouse passed that the tax liability is, we need liquidity to pay it. And so we usually see second to die life insurance, and that's what we've illustrated here, inside of a life insurance trust. Now, I have seen situations in the past where term life insurance was used and used effectively. For instance, if we have a client and let's just say their net worth is a nice round $100 million, and of that 100 million, 90 plus million is equity that they have in a business that they've built. They may have purchased a substantial term policy in order to cover the estate tax liability if they were to pass before the business was sold. In a situation like that, it would make all the sense in the world to transfer the term policy into a life insurance trust, because we wouldn't want to have to pay estate tax on the death benefit. But more often than not, we're solving for a permanent need, which is an estate tax liability at second death. And that's why we see that second to die policy instead of term.
Got another question here. It says, if someone dies today and doesn't use his or her estate tax exemption, and say 12 million goes to the surviving spouse, which would be either an outright marital bequest or to a marital trust, and then the law sunsets in 2025, does that ported exemption stay at $12 million? So the first thing is, yes, they actually have to port it. So you have to file that estate tax return and port it to yourself. And the ported amount will be safe. It will not change. Only the living spouse's exemption will be affected by the sunset. Now, there's all sorts of complicated rules that come into play if the surviving spouse remarries and to what extent they make gifts in the future, because you want to use the ported exemption first to make any gifts, because it's kind of a use it or lose it situation, and that can get really complicated. But that should answer that question.
Another question that came through is around the tax basis of some of the gifted assets. And I will go back to the SLAT illustration because it was specific to that. Assets that you own at the time of your passing do receive a step up or a reset in cost basis. So for example, if I had bought Apple at $50 a share, If I sold it today where it is around 160, I'd pay capital gains on that difference of $110 per share. If I held that apple till the time I passed, transferred it to my children, and they sold, their tax liability would be from my date of death valuation, call it 160, and the time they sold it, which if it was next day, there wouldn't be very much change. So there wouldn't be tax liability. That unrealized gain goes away at death. When you gift assets into any vehicle for the benefit of a spouse or for subsequent generations, your cost basis will transfer into that new vehicle. And because it's no longer part of your taxable estate, it has been removed, which we did by design to eliminate it being subject from estate taxes. It will not receive a step up in cost basis at the time that you were to pass. So these assets that are placed into the SLAT will have the original basis. Now, one of the things we see with the way these SLATs are typically structured is there can be a power for you to substitute assets of equal value into this trust at a later date. So for instance, if you had gifted stock and it had appreciated over time, you could take from your assets cash equal to the value of that stock, place it into the SLAT, and you take back the appreciated asset that was in the SLAT previously. Now, at your passing, that asset that you hold, the appreciated stock, would get a step up in cost basis, but those powers have to be drafted into the trust agreement. And that's where the careful identification of which of these vehicles is most appropriate for you based on your goals and objectives and your facts and circumstances and how that should be structured is so incredibly important.
And we still have time, and there's a few more questions. Can you talk about tax filings required for the SLAT? So that goes to the grantor trust question. So since you were just talking about SLATs, you want to take that one? Who pays the taxes for a SLAT?
So the answer is it depends. More often than not, SLATs are structured as what we call a grantor trust for income tax purposes, which means while these assets are outside of your estate, the gains and the income that the trust produces comes back to you and is paid personally on your 1040. Now, sometimes that seems counterintuitive because we've gifted these assets that, yes, while we have a spouse that can benefit, it's primarily for my kids and subsequent generations. Why would I continue to pay a tax liability on something that's earmarked for someone else? Well, every time you are paying that tax, while not literally, figuratively, you are making an additional gift to that trust because you're absorbing a tax liability that would otherwise be borne by the trust. So this trust, which is outside of your estate for estate tax purposes, grows without the drag of income or capital gains tax. Your estate, which likely will be taxable at the time of your passing, is getting decreased annually by the amount of the tax liability you are paying on behalf of the trust.
Let's see. Could you please reflect on a couple with assets less than $5 million? So I guess this is a question about what if you don't have a taxable estate? And what I would say is back to the beginning, you need to make sure that you have your basic estate plan all buttoned up. And even though you don't have estate tax exposure, you're going to be dealing with a portability election if one spouse dies. And you really need to decide whether you want that creditor-predator protection of a marital trust at the first death. We see this a lot, especially in blended families when there's children from prior marriages. It's a way to make sure that the money stays in the family because having a marital trust will protect the surviving spouse from being taken advantage of financially if they develop Alzheimer's or dementia, or if someone tries to take financial advantage of them. Again, those assets in the marital trust are protected. Also, if they're in a lawsuit, whoever's suing them, if the trust is structured properly, they can't pierce that trust. So for asset protection purposes, having the marital trust at least at the first death is a good option. And then you, no matter what size your estate is, if it's 5,000, 5 million, 500 million, you still have to ask yourself, what's the financial maturity of my children? And what do I want to do to protect them from themselves, from creditors and creditors? And should their inheritance go to them outright or go to them in trust? So those same basic questions apply whether you have a taxable estate or not.
And Scott, we're getting a lot of questions that are coming through now that are asking about different types of estate planning vehicles, like qualified personal residence trust, domestic asset protection trust, family limited partnerships. We're getting some questions specific to how would this apply if my goals and objectives were to transfer to certain beneficiaries, maybe not my kids, but nieces and nephews. And so I think this is a great place for us to pause. Hopefully the value of our presentation today is to give you an idea of what the estate tax landscape looks like today and where it may be heading in the future. Estate planning and the strategies that we shared today, they are, in a perfect world, customized for you, your balance sheet, your tax basis in the assets that you own, and what your goals and objectives are for yourself, for your heirs, and for charitable beneficiaries. And so what I would encourage you is reach out to the senior wealth advisors that you work with currently. Hopefully, this is not your first sight of Mariner GPS and our financial planning tool. Is work with them to really articulate what your goals and objectives are, and then we can help identify what sort of strategies, maybe what we cover today, or potentially other estate planning vehicles might be best suited to help you achieve the goals and objectives that you have. So while in an audience of 300 plus, which we had today, and we appreciate everybody's time and energy and attention, we can't get into some of the specifics on a case-by-case basis, but good news, your advisor, with the help from Scott and myself and our teams, absolutely can do that as a follow-up to this call.
All right. Well, with that, we thank you for your attendance. We thank you for the good questions, and we hope that this has stirred some thoughts and questions in your mind about your situation and maybe what you can do going forward. So thank you all and take care.